Welcome to the Deep Dive. We're the show that grabs a big, complex stack of source material, and today, wow, it spans the legal and political foundations of the entire ancient Mediterranean, and we give you the core insights, the surprising stuff, without you having to wade through it all yourself.
Exactly. And today we're really setting up a major contrast. We've got sources covering, gosh, almost a millennium. We're looking at Greek city-state conflicts, the nuts and bolts of Athenian democracy, and then shifting to the huge, intricate, and let's be honest, often pretty brutal system of Roman law and how they ran their provinces.
Right, and our mission here is pretty clear, isn't it? We want to pull out the essential DNA, you could say, of Western political thinking by putting two models side by side. How did they handle law? Where did the real power sit? And, what did justice actually feel like for an average person in democratic Athens compared to someone living under Roman rule out in the provinces?
It's really a shortcut, we hope, to understanding these two fundamentally different ways Athens and Rome approached governing. They set patterns we still grapple with.
Okay, so let's start with the big picture. Where did legal authority even come from in these two worlds? That seems like the fundamental split.
It really is. If we look at the Greek model, particularly Athens, the idea, at least, was that authority rested with the citizens, the collective body, and it was administered through these large courts, juries made up of fellow citizens.
Okay, so inherently sort of bottom up, in theory, even if reality was messy. Now contrast that with Rome, especially when the empire got going.
Oh, completely different. Rome, particularly out in the provinces, was deeply top-down, hierarchical. It revolved around the magistrate, the governor, the proconsul or legate, who was basically the emperor's representative, acting with enormous power, far from any central oversight in Rome itself.
Like a mini emperor on the spot.
Pretty much. And this core difference shapes everything about how they handled conflict. In Athens, the whole political project, you could argue, was about moving the resolution of disputes away from private hands and into the public sphere, the city's sphere.
This wasn't just a legal tweak then.
No, it was a huge cultural shift. And actually, Greek tragedy shows this brilliantly.
Ah, you're thinking of the Oresteia, the story of Orestes, the blood feuds.
Exactly. Aeschylus uses that story, the endless cycle of revenge killings in the house of Atreus, to dramatize this very shift. The answer to these terrible family conflicts, these blood feuds, moves decisively away from the private household, the oikos, and into the central authority of the city, the polis.
So the city steps in and says, okay, enough vengeance. We'll handle this through law.
Right. The city tries to internalize it, channel it, make it rational, hopefully end it, through formal public legal processes. Becoming a citizen, a member of the polis, meant submitting to this public authority instead of just answering to your family head.
Justice becomes a community project, something vital for keeping the city stable. The state is actively trying to take over the family's traditional power to judge and punish, which, as you said, is the absolute opposite of where Rome started.
Totally opposite. Early Roman society wasn't built on the state absorbing family power. It was built on the massive, almost sacred authority of the father figure, the patriarch. This is wrapped up in that famous concept, patria potestas.
Paternal power.
Right, patria potestas. You hear that term constantly in Roman law. But how did that kind of absolute family power fit with, building a republic with laws and elected officials?
Well, that's the core tension, isn't it? As scholars like Henry Maine pointed out, in very early societies like Rome's, pretty much all legal status, all rights, were kind of bundled together under the authority of the head of the family, the paterfamilias.
And this power was extensive.
Immense. It covered property, definitely, but often, crucially, it included power over the life and death of dependents. That could mean adult children, slaves, anyone under his roof.
So an individual family member didn't really have their own separate legal identity? Not fully, no. Not while the paterfamilias was alive. For a very long time, a Roman son, even an adult man, only got full legal independence, the ability to own property outright, make contracts in his own name, sue or be sued directly when his father died.
Wow. So the real, absolute dictatorial power started in the home.
Exactly. In the private household. The state, when it developed its republican structures and laws, had to sort of figure out how to layer its own authority on top of or alongside this incredibly powerful, pre-existing private authority structure. It wasn't replacing it, not initially.
Okay, so let me see if I've got this contrast right. Athens tried to pull justice into the public square, making it a city matter to stop private feuds. Rome starts with this almost tyrannical power within the family, and when that power structure gets projected outwards into the state, it keeps that top-down, hierarchical, status-based feeling.
That's a really good way to put it. The starting points dictate very different trajectories for how law and power operate. #2, law and accountability in Athenian democracy.
Now, the Athenian system, built on this idea of citizen power, wasn't naive, was it? They seem to have understood the risks of giving politicians too much power. The sources talk about specific legal breaks they put on.
Oh, absolutely. They were very aware of how political power could be abused. They built in some fascinating constraints specifically designed to stop the elite from basically using the law as a weapon against their enemies.
Right, not just relying on juries, but actually building structural safeguards against, say, laws designed just to hurt one person.
Precisely. The key was the distinction they made between a general law, a nomos, which was meant to be permanent and applied to everyone, and a temporary decree, a sophisma, which was more for specific, immediate issues.
Okay, so how did that distinction work as a safeguard?
The fundamental rule was you absolutely could not propose a new nomos, a general law, that targeted a specific named individual unless that law applied equally to all Athenians.
Ah, I see. So if you wanted to get your political rival, you couldn't just pass a law saying exile Bob. You'd have to pass a law saying anyone who does X is exiled, knowing it might bite you or your friends later.
Exactly. It forced a kind of constitutional equality. It was meant to stop those custom-made laws designed purely to ruin someone or grab their stuff, something you saw all the time in oligarchies. And furthermore, those easier-to-pass decrees, the sophismata, were legally supposed to align with the general laws. They couldn't contradict the nomoi.
So you couldn't use a decree to give special favors or punishments either.
Well, you weren't supposed to. If a decree tried to grant special privileges to one person or impose a penalty on just one person in a way that violated the principle of equality under the general law, it could be challenged as illegal.
Okay, but how do they actually enforce that? Who stopped a powerful politician from pushing through an illegal decree?
Any citizen could bring a specific legal challenge. It was called the graph paranoma, basically an indictment for proposing illegal things. This put the guy who proposed the decree on trial in front of a jury.
High stakes, then.
Very high stakes. It was a way for ordinary citizens to act as guardians of the Constitution, to protect the integrity of the nomos. If the proposer lost the case, they could face heavy fines or even lose their political rights entirely. It was a powerful check.
So citizen oversight built right into the legislative process. Fascinating. But Athenian law wasn't all about careful procedure. It could be incredibly harsh, too, right? Especially when it came to maintaining order.
Oh, definitely. Look at Draco's homicide law. It's famously severe, particularly the bits about exiles who dared to come back.
What happened if an exiled killer snuck back into Attica?
The law was brutal. Any citizen was legally permitted to kill them on sight or arrest them summarily, this procedure called apagoge. No new trial needed.
Just execute them in the street.
Essentially, yes. It shows how seriously they took the finality of exile. Banishment was often a political tool, remember? The state needed to ensure people stayed banished.
And they even protected the people who carried out these summary executions.
Yes. The law explicitly shielded citizens who denounced returning exiles, and eknufton, from being prosecuted for homicide later, even if the exile was killed as a result of their denunciation. It underlines that the state's priority maintaining order, enforcing its judgments, could sometimes completely override what we'd consider individual due process.
But what happened when that state power itself got corrupted? When the safeguards failed? The 30 tyrants seem like the nightmare scenario.
Absolutely. That brief, bloody period when an oligarchy took over Athens is a classic example of justice collapsing. And the sources are pretty clear. The 30 weren't just acting out of some political ideology. A lot of it was just pure greed.
They used their power to enrich themselves.
Massively. They started filing bogus impeachments, targeting wealthy citizens, people like Leon of Salamis. The aim wasn't necessarily political opposition. It was to confiscate their assets.
So using the legal system for outright theft.
Precisely. The orator Lysias, who lost family and property under the 30, called this process of fake accusations and seizures the beginning of the whole evil business. It just shows what happens when those constitutional checks disappear. The legal system instantly becomes a tool for plunder.
Which really brings us back to why public perception was so vital in Athens. The citizens, the jurors, had to believe the system had some integrity.
Exactly right. That's why the speakers in court were constantly reminding the jurors, the dikastai, that their decisions had consequences beyond just the case at hand. They'd say things like, the city will be judged by the character of the man you choose to honor or condemn.
Implying that every trial was a reflection on Athens itself.
Yes. Every verdict was a moment where the city's reputation for justice, for fairness, for upholding the value of its citizens was on the line.
Now let's contrast that Athenian ideal, even when it failed, with a famous case from Sparta where accountability just evaporated because of influence.
The Sphadrius raid. Yes, that's a perfect contrast. Sphadrius was a Spartan commander. He launched this completely unprovoked, botched night raid on Athens' port, the Piraeus. It was a massive diplomatic incident risking a major war.
Clearly illegal, clearly against the peace treaty. He should have been punished severely.
You'd think so. But he got off, entirely because of King Agesilaus' influence.
Why did the king protect him?
The sources suggest it was personal. Apparently, Sphadrius' son was close friends with Agesilaus' own son, but the official justification Agesilaus supposedly gave was just astounding.
What did he say?
He basically argued, look, Sphadrius is guilty, obviously. We all know that, but it's tough to execute a guy who's generally been an honorable soldier, and frankly, Sparta needs soldiers like him.
Wow. So military usefulness and connections trumped the actual law and the risk of war.
Completely. And the source we have explicitly calls this a grave mistake of policy. It points out that the Athenians, for all their faults, were actually known for holding their own generals accountable for much less serious offenses. It highlights how Spartan justice could just break down when personal influence or perceived state need overrode legal principles.
So Athens, justice is debated, politicized, needs public buy-in, even if corruptible. Sparta, justice can be overridden by elite influence and military expediency. And Rome, as we're about to see.
Right.
Well, that's often about the raw power of one official.
Right. Moving from the Greek polis to the Roman Empire, especially the provinces, is like shifting from a noisy courtroom to the quiet, imposing office of the Roman governor, the proconsul, or the legate. The power dynamic changes dramatically.
This governor wasn't just pushing papers, were they? They were the face and the fist of Rome, hundreds of miles from the Senate. Where did their power come from, and how far did it reach?
Well, locally, within the provinces, individual towns and cities often handled their own day-to-day minor criminal stuff, but the governor held what was called extraordinary criminal jurisdiction, extra ordinem.
Extraordinary, meaning outside the normal rules.
Exactly. It was basically the full power, the imperium, that a consul held back in Italy, but wielded out in the provinces, often without the usual senatorial checks and balances. It allowed the governor to bypass local courts and procedures, to act fast, decisively, and sometimes very arbitrarily.
The word improvised really does seem to fit here. Miles from Rome, dealing with local unrest or challenges, the governor had to be the law, the judge, the enforcer, all rolled into one just to keep order. That sounds like a recipe for abuse.
It absolutely was. The potential for summary justice, even brutality, was baked into the system. And we have chilling examples. Think about Quintus Scaevola when he was governor of Asia.
What did he do?
He had the chief manager of the publicans, the powerful private tax collectors, crucified right after the guy had apparently paid a huge ransom and was expecting to be released.
Crucified him after the ransom was paid. What's the message there?
The message is, I am the ultimate authority here. Your deals, your money, mean nothing compared to my power as Rome's representative. It's about demonstrating absolute dominance, not following legal niceties.
And that wasn't an isolated incident.
Sadly, no. We hear of another governor in Asia, under Augustus this time, who apparently had 300 people beheaded in a single day.
300.
300. It's hard to even grasp. But that single horrifying anecdote just shows the sheer scale of unchecked power. This wasn't justice as deliberation. It was justice as shock and awe, designed to maintain the Pax Romana, the Roman peace, through sheer terror if necessary.
And this brutality wasn't just random, was it? It seems like it was systematically applied based on who you were. Which brings us to that infamous dual penalty system.
Absolutely central to understanding Roman provincial justice. They didn't even pretend everyone was equal before the law in terms of punishment. The principle was stated quite openly. Not all can suffer the same penalties. This explicitly divided society into two tiers for legal purposes: the higher status honestiores and the lower status humiliores.
Okay, let's break that down. Who were the honestiores and what happened to them if they broke the law?
The honestiores were the elite, senators, equestrians, the sort of business class, wealthy local landowners, decurions, local town councilors. For them, the death penalty capite puniri was extremely rare, usually only for high treason maiestas.
So what were their typical punishments?
Things that removed them from power or society without physical degradation. Exile was common, either deportatio, which was harsher and permanent, or relegatio, often temporary. Or they could be kicked out of the Senate or their local town council, modio ordian. And critically, honest jurors could almost always avoid being thrown in prison before their trial, a huge privilege.
Okay, so disgrace, loss of status, exile, but generally avoiding the brutal physical stuff. Now, contrast that with the humiliaries. This is basically everyone else.
Pretty much. Laborers, peasants, artisans, the poor, non-citizens, in many cases the vast majority of the provincial population. Their fate was starkly different. They faced what the Romans called summum supplicium,
Which means?
the highest penalty, basically. It covered the most severe, aggravated forms of execution, often designed to be incredibly painful in public spectacles, exposure to wild beasts in the arena bestias dari, being burned alive, vivissuri, and, of course, the most notorious crucifixion, the crux.
And if they weren't executed,
Other common penalties included life sentences, doing hard labor in the mines ad metallum, which was often a death sentence in itself, or just widespread, brutal corporal punishment, flogging.
Yeah.
And unlike the elite, they absolutely could be imprisoned before trial.
it seems so deliberate. Why make the punishments for the lower classes so agonizingly public and brutal?
It looks very much like a system designed to control the masses through fear. The honestiores were kept in line through threats to their status and wealth. The humiliores, the backbone of the labor force, but also the potential source of unrest, were controlled by the constant visible threat of horrific pain and death.
It wasn't a bug, it was a feature. Systematic differentiation of justice to maintain order.
Precisely. Terror directed at the lower classes wasn't an abuse of the system. In many ways, it was the system of provincial control.
And the governor wielding this power wasn't entirely autonomous, right? They still answered ultimately to the emperor back in Rome. How did that relationship work in practice?
There was a constant need for confirmation and guidance from the center. We see this really clearly in the letters between Pliny the Younger, when he was governor of Bithynia and Pontus, and the Emperor Trajan.
What were they writing about?
Pliny wrote to Trajan asking about a fairly specific legal point. Should cities have priority when trying to recover debts owed to them from public contracts, like rentals or sales?
Seems like a technicality. Why bother the emperor?
Because, as Pliny himself noted, even though previous governors had allowed cities this priority, it was just based on their own authority, a kind of temporary practice. For it to become a permanent, province-wide, real established law, Pliny needed Trajan's explicit imperial confirmation.
So even established local practices didn't have the force of permanent law without the emperor's stamp of approval.
Exactly. It constantly reinforced that all ultimate legal authority flowed from the emperor. Status, privileges, permanent regulations, they were all granted from the top down.
Like when emperors granted citizenship.
Perfect example. Citizenship was often given as a personal reward, a beneficium from the emperor. Or think about Emperor Hadrian when cities like Delphi or Estapolia sent embassies asking him to confirm their traditional rights and autonomy. He responded with personal letters directly to their city magistrates. It was a constant performance of imperial authority being the ultimate source of all rights and law. #HagOV, core Roman legal concepts and social structure.
Okay, so we've seen the harsh realities of Roman power in the provinces. But to really get the Roman legal mindset, we should also look at the foundations, the civil law they developed, which was often incredibly detailed and, well, philosophical in its own way. It's quite a contrast to the public drama of Athenian courts.
It is. And a good place to start is right back at the beginning, looking at how intertwined their early law was with ritual and religion, especially around things like property.
How so?
Well, in ancient law, before widespread literacy and standardized documents, transferring property or making important contracts wasn't just signing a paper. It involved elaborate ceremonies, specific symbolical acts and words.
And lots of witnesses, right. The sources mention an inordinate number of witnesses.
Exactly. Why? Because in an oral or semi-oral culture, the ceremony and the witnesses were the record. The whole point of the elaborate ritual, the symbolic gestures, the crowd of people watching, was to physically impress the transaction onto the collective memory of the community.
So if there was a dispute later, you'd have dozens of people who could say, yes, I was there. I saw the symbolic clod of earth handed over. I heard the specific words spoken.
Precisely. The form, the ritual, was paramount, sometimes even more important than the actual intent if the form wasn't followed correctly. It wasn't about abstract legal principles yet. It was about concrete, memorable actions.
And this connection to ritual
Yeah.
even extended to basic citizenship.
Oh, yes. In early Rome, being a citizen wasn't just about birth. It was tied to participating in key religious ceremonies of the state. For example, to have full political rights, you had to be present for the lustrum, this big purification ceremony with prayers and sacrifices.
If you missed it.
You could temporarily lose your rights as a citizen, at least until the next lustrum was performed. It shows how deeply embedded religious obligation was in the very definition of being a Roman.
We can see glimpses of this ancient formalism in their first written laws, the 12 Tables, from way back in the 5th century BCE.
The 12 tables are fantastic for that. They give you these little snapshots. For instance, look at the rules around penioris capio, seizing property as a pledge for a debt.
What did they say?
It wasn't a general right to seize property for any old debt. The 12 tables specifically allowed it for very particular debts, often with a religious connection. Like if someone failed to pay the agreed price for an animal they bought specifically for a sacrifice, costume, or if they failed to pay for renting a draft animal that was used for a sacrificial feast, dapum.
So even basic debt enforcement prioritized obligations related to religious rituals.
It seems so. It suggests that the early state's power to enforce debts was perhaps first applied to ensuring these crucial community religious obligations were met.
Okay, fast forward to the classical period, when Roman jurists were developing incredibly sophisticated ideas preserved for us mainly in Justinian's Digest. Let's talk about contracts. How did they define something like mandate or agency?
Mandate was basically an agreement where one person asks another to perform a service, often as a favor, based on trust. Sides. The jurists worked out a neat balance. You were totally free to refuse a mandate, no obligation to accept. But once you accepted it, you had a duty to carry it out properly.
What if you didn't, or just changed your mind?
If you failed to complete it through your own fault, or if you backed out without giving reasonable notice so the other person could make other arrangements, you could be sued. There was an action on mandate to recover damages.
So even agreements based on friendship or trust had real legal teeth if you didn't follow through diligently.
Yep.
What if the mandate was, say, to buy something for someone, and you messed it up?
If you received a mandate to buy something and failed, maybe you just didn't bother. Or you were negligent, you were liable to the person who gave you the mandate for any loss they suffered. It reinforced that taking on even an unpaid task created a binding legal obligation.
Okay, shifting gears a bit. What about more complex financial dealings, like selling a debt? Can you even sell a debt?
Oh yes, the Romans did that. And their rule was actually very practical and quite modern sounding. When you sold a debt, meaning you transferred your right to collect money from a debtor to someone else, the seller was generally only responsible for one thing, guaranteeing that the debt actually existed, that the person named was legally a debtor.
But not responsible for whether the debtor could actually pay.
Exactly. Unless you specifically agreed otherwise, the seller did not guarantee the debtor's solvency. The risk that the debtor might turn out to be broke fell on the person who bought the debt.
That makes sense. The buyer takes the risk, presumably after assessing it. It guarantees the thing being sold, the legal claim, exists, but not its ultimate value.
Right. It makes trading debts much easier because the seller's liability is clearly limited. It avoids endless arguments about who knew what about the debtor's finances. Very practical.
Okay, one last Roman legal concept, and it's a fascinating one. Theft. Specifically, this idea of needing an honest interest to sue.
Yes, this is quite subtle. The basic rule was, to bring an action for theft, actio furcae, you had to be either the owner of the stolen property or someone else who had a legitimate, honest interest in the property not being stolen.
Like who? Who else besides the owner has an honest interest?
Maybe someone who had borrowed the item and was responsible for its safe return, or a craftsman who had the item for repair, or even a seller who hadn't yet delivered the goods to the buyer. They all had a legitimate reason recognized by law to care about the property's safety.
But the classic example of someone who couldn't sue is the most revealing, isn't it?
Right. The first thief cannot sue the second thief if the second thief steals the stolen goods from him.
Why not? The first thief clearly has an interest in keeping the goods.
But the jurist said his interest wasn't honest. It stemmed from his own wrongdoing. The law essentially refused to protect possession that was acquired dishonestly. It wouldn't grant a legal remedy based on an improper gain.
So there's a moral layer there, even in property law. The right to sue for theft required clean hands, so to speak.
Exactly. The legal system drew a line, reserving the right to sue for the original rightful owner or someone with a similarly legitimate connection to the property. It's a fascinating glimpse into how they balanced practical property rights with underlying ideas of justice. Hashtag outro.
Wow. Okay, so this journey through ancient law really highlights two incredibly different worlds, doesn't it? On one hand, you have Athens striving, at least in theory, for justice through citizen participation, aiming for a kind of equality within the polis, trying to tame private vengeance with public law.
And on the other hand, you have Rome, especially out in the provinces, where the system was just fundamentally hierarchical, defined by the governor's immense, often unchecked power, and this stark legal divide between the elite honestiores and the rest, the humiliores. Law there feels much more like a tool for maintaining order and reinforcing status.
So maybe the bottom line is, Athenian justice was often a form of political theater, needing legitimacy from the community. Roman provincial justice was more like a pragmatic, sometimes brutal instrument of state control.
I think that's fair. And when you look closely at those powers, the Roman governor had especially the power to inflict summum supplicium, these horrific public executions like crucifixion, but only on the lower classes you really see that system in action. It confirms that Roman order didn't rely on everyone following the same rules. It relied on systematically treating people differently based on their status.
Which leaves us with a final thought for you, our listeners, to mull over. Think about that Roman provincial governor's power, that ability to use summary death, often in very public ways, primarily against the humiliores. Was this just random cruelty, or was it a calculated strategy?
Consider this. Maybe that system, which used deliberate terror against the majority to keep them in line and reinforce the authority of the local elites in Rome itself, wasn't seen as a failure of justice by the Romans. Maybe they saw it as the most practical, even efficient way to hold together a vast, diverse empire. Was an arbitrary power, the very thing we see as unjust, actually considered essential for maintaining stability on that scale?
Something to think about. Thank you for joining us for this deep dive into the laws of Athens and Rome.
We hope you found it illuminating. See you next time.